The judge slammed his gavel and stared at Regina, stunned that she'd filed suit against land older than her HOA. "You tried to steal property protected since 1876? He asked, holding up my great-great-grandfather's original deed in evidence. Regina's face went white as the courtroom erupted. Months of harassment finally about to catch up with her. "My name is Daniel Marsh, a carpenter raising 2 kids on land my family has owned for 5 generations. Our 5-acre plot sat inside newer subdivision boundaries, though our deed predated the HOA by over a century. Regina Voss ruled the Cedar Hollow HOA like a queen, obsessed with matching mailboxes and pristine, uniform lawns. She'd moved in 3 years earlier, buying the board with casseroles and threats disguised as neighborly concern. Neighbors whispered she once forced a widow to repaint her door 4 times over unapproved beige. I stayed quiet, minded my land, and figured our old deed made us untouchable to her petty rules. Then Regina spotted my grandfather's hand-built cedar fence and declared it violated the community's modern aesthetic standards. She left a violation notice demanding I replace it with vinyl paneling within 30 days or face fines. I told her calmly that my property predated the HOA and wasn't legally bound by her design rules. Regina laughed, insisting every parcel inside the mapped boundary answered to her board. "No exceptions allowed." "We'll see about that," she said, snapping a photo of my fence like it was a crime scene. Within a week, fines started arriving, absurd numbers stacking up for a fence that predated her subdivision entirely. I called the county clerk, who confirmed my land was never legally annexed into the HOA's territory. Armed with that, I mailed Regina a polite letter clarifying the boundary error and requesting fines withdrawn. She ignored it, instead posting my address in the community Facebook group, calling me a rule-breaking outsider. Comments piled up. Strangers judging my fence, my truck, even my kids' bikes left in the yard. My wife Carla worried the harassment would escalate, but I believed facts would eventually silence Regina's campaign. Instead, Regina convinced the board to place a lien threat on a property she had no jurisdiction over. I visited the county recorder's office, printing certified copies of our 1876 deed for safekeeping. The clerk mentioned Regina had already stopped by asking how to correct boundary maps in her favor. That struck me as odd. Correcting maps sounded less like mistake fixing and more like quiet manipulation. I started documenting everything: emails, notices, screenshots, timestamps, building a folder labeled simply Regina. My neighbor Pete, a retired surveyor, offered to walk our property line and confirm the historical markers. He found the original 1876 stone markers still intact, decades untouched, proving our boundary never moved. Regina, hearing this, doubled down instead of backing off, calling Pete's findings unofficial and irrelevant. She hired her own surveyor, someone she'd used before, hoping for a report favoring HOA control. That surveyor, to my surprise, called me directly to ask honest questions instead of just complying. His name was Marcus, and something in his tone told me he wasn't fully on Regina's side. For 2 weeks, things quieted down. No notices, no posts, almost suspiciously peaceful around our property. Carla relaxed slightly, hoping Regina had realized her legal footing was weaker than her ego admitted. I kept building fence repairs anyway, treating myself to normal weekends without lawyers or angry letters. My daughter Emma asked why the fence lady stopped yelling, and I told her adults sometimes retreat quietly. Marcus called again, hesitant, saying Regina had requested he adjust his survey numbers before filing anything. I asked if he'd comply, and he simply said he needed time to think about it. Then Regina filed something far worse, a quiet title lawsuit claiming disputed ownership over our exact acreage. A process server showed up at dinner, handing me papers claiming the HOA held superior title. Carla's hands shook reading it, terrified we could somehow lose land passed down 5 generations. Called a lawyer, Denise Alvarez, who read the deed and simply said, This is reckless. Denise explained quiet title suits usually target unclear ownership, not documented deeds predating the plaintiff's existence. She suspected Regina either misunderstood the law or deliberately weaponized it, hoping we'd settle from fear. Regina's social posts escalated too, calling me a squatter hiding behind fake old paperwork. Neighbors who once liked me started avoiding eye contact, swayed by her confident, repeated accusations. My son Tyler got teased at school. Kids repeating rumors their parents whispered about our illegal land. I felt the injustice sharpen, watching Regina rewrite our history using nothing but volume and confidence. Denise filed a formal answer, attaching certified deed copies and Pete's documented survey findings. Regina's lawyer requested a continuance, oddly delaying instead of pushing an easy win she claimed to have. That delay felt strange, like someone scrambling behind the scenes to shore up a weak case. Marcus, the surveyor, finally called Denise directly, saying he needed to disclose something troubling. He revealed Regina had asked him to backdate a survey to suggest recent boundary changes existed. That request, true, meant Regina wasn't confused about the law. She was trying to fabricate evidence. Marcus refused, but admitted Regina hinted she'd find someone else willing to falsify the paperwork. Denise asked him to put everything in a sworn statement, and he agreed without hesitation. For the first time, I felt the tide quietly shifting away from Regina's manufactured narrative. Regina, sensing resistance, escalated further, filing an emergency injunction to halt all activity on our land. A sheriff's deputy arrived awkwardly, explaining he had to post notice restricting fence repairs immediately. Carla cried that night, exhausted from months of being treated like criminals on our own property. I refused to feel defeated, reminding my family the deed itself hadn't changed. Only Regina's desperation had. Regina then contacted our mortgage lender, falsely claiming unresolved title disputes threatened our loan standing. The lender froze a pending refinance, adding financial pressure to an already exhausting legal nightmare. I later learned Regina once did this to another homeowner, who'd quietly moved away in defeat. That homeowner, Grace Lou, reached out after seeing my public posts, offering to testify against Regina. Grace explained Regina had manipulated her HOA position for years, targeting anyone questioning her authority. She'd saved emails proving Regina pressured board members into approving actions without proper community votes. Denise added Grace's evidence, building a pattern showing deliberate abuse rather than one honest mistake. Regina, unaware evidence was mounting, grew bolder, showing up uninvited to inspect our property personally. She trespassed past our gate, photographing our children's swing set, calling it unauthorized structure. I calmly recorded the encounter on my phone, refusing to let anger override documented, lawful response. Regina threatened to have us evicted once the court sees things her way, voice shaking with certainty. That confidence felt less like conviction and more like someone desperate to control an uncontrollable outcome. Denise discovered Regina had quietly transferred HOA funds toward hiring an aggressive outside attorney for the suit. Board members, unaware of full costs, began asking uncomfortable questions during a tense community meeting. One board member, Harold, admitted Regina rarely brought major decisions to formal votes anymore. The court finally scheduled our hearing, 3 months after the harassment first began over a simple fence. Denise prepared meticulously, organizing deed copies, survey reports, Marcus's statement, and Grace's testimony chronologically. Carla and I barely slept, replaying every notice, every insult, every sleepless night leading here. Regina posted online that victory was guaranteed, rallying supporters to fill the courtroom gallery. I worried briefly, wondering if confidence like hers sometimes swayed judges regardless of actual evidence. Denise reassured me judges respected documentation far more than social media bravado or rehearsed outrage. The morning arrived cold and bright, and I dressed carefully, feeling strangely calm despite the stakes. Emma hugged me before school, whispering, "Don't let the fence lady win, Dad," which steadied my nerves. Pete offered to testify about the stone markers, still standing exactly where they'd stood since 1876. Marcus confirmed he'd testify honestly, regardless of pressure Regina had applied months earlier. Grace arrived early, sitting quietly beside Carla, both women united by Regina's pattern of abuse. I walked into the courthouse holding the original deed, protected inside a simple leather folder. Regina's attorney opened confidently, claiming boundary confusion justified the HOA's quiet title claim entirely. Denise countered immediately, presenting the certified 1876 deed, showing unbroken ownership across 5 generations. The judge examined the document closely, noting its recording date predated the HOA's incorporation by decades. Regina's attorney pivoted, arguing recent survey discrepancies supported their claim, referencing Marcus's original report. Denise called Marcus to the stand, and he calmly described Regina's attempt to falsify boundary data. Gasps rippled through the gallery as Marcus detailed her request to backdate manipulated survey results. Regina's face tightened, her confident posture cracking under sudden, unexpected public exposure. Denise then called Grace, whose testimony revealed Regina's years-long pattern of manipulating vulnerable homeowners. The judge's expression hardened, clearly troubled by the picture forming beyond just our single case. Regina's attorney requested a recess, but the judge denied it, wanting the full record established immediately. Harold, the board member, then voluntarily testified that HOA funds were misused without proper community approval. Regina stood abruptly, insisting the testimonies were personal vendettas, her voice rising with visible panic. The judge reminded her sharply that outbursts wouldn't change documented evidence sitting plainly before the court. The judge reviewed everything once more, then addressed Regina directly, tone firm and unmistakably final. "This deed predates your HOA's existence entirely," he said. "There was never a valid claim here." He dismissed the quiet title suit immediately, calling it a reckless abuse of legal process. Then he referred Marcus's testimony regarding falsified survey data to the district attorney for review. Regina sat frozen, realizing her attempted manipulation had just been read into permanent court record. The judge further ordered the HOA to reimburse our legal costs, citing bad faith litigation conduct. Outside, reporters who'd heard about the case asked Regina for comment. She offered none, hurrying away. Weeks later, the HOA board removed Regina from her position, citing repeated abuse of authority. Grace and 2 other families finally felt safe reporting similar harassment, prompting a formal community investigation. Our fence still stands exactly where my great-great-grandfather built it, proof that truth outlasts every Karen. Van D.